Hot stove conversations about baseball, history, football, and current events that may leave you saying there's more to consider. Now, here's your host, Jack Moore.
Welcome to More to Consider. I'm here with my friend Charles Hundley. Charles, how are you?
I'm doing all right. Yourself?
I'm doing okay. We do our talking off the air like we talk about every show, or I always run my mouth about it. We're both history buffs for sure. And I think to some degree, we have a lot of interest. We have interest in current affairs, no doubt. But being history buffs, it's always like in light of history, what does the following things mean? So we're talking about things contemporary and historical. And what we're going to talk about in this episode is really difficult, I think, to find a right answer, which is sometimes not so easy. We want to talk about birthright citizenship, and it's getting ready to go to the Supreme Court. Looks like Trump versus Barbara is the case. I think it's April 1 that the Supreme Court's actually going to rule on this. And man, there's a lot of history. And there's a lot of history and discussion on what does it mean to be a citizen and what does all that entail, etc. So just going in, give me your overall feelings as we go into this discussion. Feelings, thoughts, where are you sort of on what you know about what's in the news?
It just doesn't make too much sense to me to even argue the fact that so long as you step foot on American soil and have a baby, that baby is automatically an American citizen. That just doesn't make any sense to me. Obviously, there are people who are going to argue that that's the case. I'm really having a hard time finding where they can read that in the 14th Amendment. But even if somehow they can read that into the 14th Amendment, can you please give me some evidence to back it up? And I've yet to run across anybody that could. It just seems to be all emotion and less fact. Like you and I've talked about before, the best thing that we can do when it comes to the framers and what they intended when it comes to the Constitution, the formation of the country, is to go back to read what they had written prior to or even after the formation of the country to get the best guess as to what they meant by what they wrote. Well, in this case with the 14th Amendment, there are people who we can actually go back and read what they meant by all of this. So I don't know why it's so difficult not to just do that.
Okay. So let's give some background. The Supreme Court will hear the case on birthright citizenship coming up on April 1. It's all based upon President Trump's January 2025, just upon taking office, an executive order regarding this. And sort of the Reader's Digest version of how we absorb what the executive order is saying. It's saying, in effect, going forward, there will not be the birth to parents not legally on American soil a recognition of citizenship merely because you were born here. But now you asked the question, and this is the key thing, or you made the statement, where sort of do we get this whole idea? I definitely, absolutely see the 14th Amendment being read that way. Absolutely. Because the plain language, and let me throw that out there too. You know, in legal training, you can take classes on it, but you definitely you have addressed to you as a law student statutory interpretation. So some government writes a law, enacts a law, maybe it's a constitutional amendment, whatever. And then you get into these different layers. And a lot of originalist people that are like, hey, the language is plain. And this is the argument clearly for the Second Amendment. For many gun rights advocates, they'll go like, hey, it says the right of the people to keep and bear arms shall not be infringed. What else do you need to hear? Well, then there's the clause preceding that kind of gives that, well, what do they mean by well-regulated militia? Does that mean, and I know what I think it means is they didn't want standing armies. We can go down the whole Second Amendment. But the people who argue for the right will just tend to say, hey, it says clearly, shall not be abridged. And I get it. It says, shall not be abridged would seem to say, and this is what we picked up on, or we discussed, or you actually stated several times in a show we did before, that would seem to mean any federal legislation addressing ownership of a firearm seems to be a problem. And that's why I've said all along, I still think states could do whatever the hell they want. But let's go ahead and look at the 14th Amendment. This is what Section 1 of the 14th Amendment says. So it's clear. all persons born or naturalized in the United States, comma, and subject to the jurisdiction thereof, comma, are citizens of the United States and the state wherein they reside. So, now this is what's key too, because I've done a lot of research here recently going into this. It comes in 1868, clearly. Well, and back up and say this too. The American Constitution is out for ratification in 1787 is when September 17th is Constitution Day, so it's 1787. Now it goes through all these phases for ratification. And in this struggle over this issue, the battle between the Federalists and Anti-Federalists, there were people that wanted the Bill of Rights. So many proposed amendments, as we've discussed. 12 were voted on, 10 made it. They became the Bill of Rights. Then things are pretty quiet. We have two cases, and I always get them out of order. The 11th and 12th Amendment, one affected states suing each other, and the other had to do with the election of 1800 and the confusion over having the president, or the vice president, I should say, come in number 2 in the Electoral College. You got two people that are opposite politically, so they come up with the idea of how the election would be run, that you vote for a president, you vote for a slate of a president and a vice president, so we don't have any more of a Jefferson and an Adams potentially serving as president and vice president, and it clears up how the election's going to be run going forward. So those things happen pretty close to the formation of the country. Then you have a pretty quiet area, or quiet era. And boom, end of the Civil War. 13th Amendment basically ends in voluntary servitude and slavery. 14th Amendment does whatever the 14th Amendment does as it relates to citizenship, but it also has a due process clause, and it discusses that there will be equal application of the law. So that's an issue that I'm going to address. And the 15th Amendment goes into voting. And it's interesting too, I always try to make this point. When they write this language, they never address a race or a sex. Like in the 15th Amendment, it says, no longer shall one's right to vote be abridged on account of race. Now, it's addressing the fact that the now freed slaves can vote legally, but the states were still, in large part, in charge of how voting was done. This is where the poll tax comes in, literacy tests and other things come into play. They're allowing the states still to regulate how people vote, but they're saying that the basis for not being able to vote will no longer be on account of race. And then when the 19th Amendment comes later and addresses, people think, well, it gave women the right to vote. What it said was, no longer could you abridge the right to vote on account of sex. Okay. So both of those addressed in the broad sense what that means. But what I think is important here is what precedes the 14th Amendment during this period. No, I was going to say 13, 14, 15 happened after the Civil War, and then it's quiet again until the Progressive Era. Then it's followed by the 16th Amendment, taxation, 17th Amendment, U.S. senators voted for by the people, 18th Amendment, prohibition, 19th Amendment, women's right to vote, or not being abridged on account of sex. So then you have the Progressive Era. But there's lulls of 50-year periods where there's not really any movement to amend the Constitution. And then there's periods where there are some amendments to the Constitution, and they are pretty big in American history. But here's what's important about the 14th Amendment's 1868. In 1866, the Congress, right after the war's over, within the year after the war's over, passed because they're concerned with what's going to happen to the newly freed slaves, especially as they're going into Reconstruction. So they passed the Civil Rights Act of 1866. And you know what it does? It defines citizenship. And then it's like, okay, we're having trouble forcing it upon the states. So they get together and they basically sort of rewrite the same language into the 14th Amendment. So further going from, okay, we pass a congressional act over the veto of Andrew Johnson. Johnson vetoes it. And then Congress has the votes. They overcome his veto and they enact the 1866 Civil Rights Act. Then, after 1868 with the 14th Amendment, they're still struggling to get the states to come into compliance. So they reenact the 1870 Civil Rights Act. So all this stuff is going on. But in conversations I've had with you, I would agree all these cats are after in 1868 is 1868. they have to look prospective and go like, okay, what's going to come in the future? But I think this is where a lot of the bombshell has been created, or the fallout from where we are, is they were addressing the issue of newly freed slaves and how the states would be brought into compliance to recognize rights. And it's turned into this. So speak on that so far, what I've said. Speak on what you think about, like what you think what their focus was.
When you read the 14th Amendment,
Mm-hmm.
you have to sort of bring grammar into this also. So if I read this sentence, I'm going to ask you, what tense, past, present, or future tense, would you think this sentence was written to address?
Good point. Okay.
It says, all persons born or naturalizing in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. If this meant, hold on, man. Hold on.
Go ahead.
If this meant to go for something that was in the future, it would say, will be citizens of the United States, right?
No, I don't think so.
You don't?
No, I don't. I think this could be definitely fairly read as all persons born or naturalized in the United States, comma. Okay, it's saying all persons born.
Yeah.
And since it's a constitutional amendment, it is going to be in full effect going forward.
Okay.
They're not addressing all, I'll be whatever. It didn't say that. It says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States.
Time out though. Time out. Are, not will be. And the reason and this is why I keep bringing up what I bring up about this. I personally believe the 14th Amendment was only supposed to apply to one specific day and not the future. Because if it was the future, it would say will be citizens. There would be no reason for it to say are. Are is really just designating that everybody who is here right now are, not everybody who's coming. It wouldn't say are then, it would say will be. Am I right? Grammatically?
I don't think, I think when you're writing or drafting the language of a constitutional amendment, you're saying this is now the law of the land unless repealed, unless it's overcome by another amendment. So if I were looking at this and I'm thinking like, what are they plainly saying? All persons born and naturalized in the United States, blah, 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 are citizens of the United States. It wouldn't matter if they were born 3 days later, because then if you looked at that person 3 days later and said, what is that person? You're like, well, according to the 14th Amendment, it says all persons born or naturalized in the United States and subject to the jurisdiction thereof, they are citizens.
But again, as we talked about this earlier, didn't the Constitution already address that? About the people who were born. Remember we were talking about Alexander Hamilton versus the other founders?
Okay.
That it specifically said that people who were born in the United States, essentially in the 13 colonies, will be considered American citizens.
I don't think the Constitution addressed it.
But it's maybe that's the case, but I do remember that. I'm going to have to find that.
No, and I listened to a lot of the stories. I've been doing a lot of listening. I've been doing a lot of reading and all that. And they're saying, and here's why. This is the important thing. One thing I saw that came up over and over was how the United States could declare independence and get into a shooting war with England. What did they have to think they were? And they talked about the common law rule, the jus soli, Jussoli, I think jus soli. I've seen it pronounced different ways, but it is this doctrine that was the British common law doctrine, that to be born, it was from a time of feudalism. So the view was you were born a subject of the king.
Oh.
You weren't born a citizen. You were born a subject. This is key, though. This is important.
I understand.
Because if you're making a declaration of independence, part of that would imply you're no longer a British subject, right? With independence, you're no longer. But they didn't get into like a textbook definition. And this is one of the things that has come up, is it's not real clear. The only other thing that you might say that addresses some level of citizenship maybe was like in the Three-Fifths Compromise. They talked about Indians not taxed and those in involuntary servitude. But they didn't say you now are a United States citizen. I think the one thing, and I don't know how clear this was really addressed in the Constitution either, but it said that you had to be you had to be natural born to be president of the United States.
So I'm going to read something to you. It says, Congress established its first uniform rule of naturalization through the Naturalization Act of 1790. The act provided that any free white person who resided within the limits and under the jurisdiction of the United States for at least 2 years could be granted citizenship if he or she showed good character and swore allegiance to the Constitution. The law also provided that the children of naturalized citizens under the age of 21 at the time of their parents' naturalization and who were residing in the United States will be considered U.S. citizens. The children of U.S. citizens who were born outside the United States were deemed U.S. citizens unless their fathers had never resided in the United States. Additionally, Congress delegated to the courts the power to administer the naturalization process. So what I just said was correct.
Well, what you just said is something that followed the Constitution. So the Constitution doesn't speak on it.
But this is the first, it's this Naturalization Act.
Right, but it's an act following the ratification of the Constitution, which means that falls within the grounds of the powers of the Congress to pass it. Yes.
Understood. But this is the first
definition of citizenship.
Correct. And that's why I said this is already taken care of before the 14th Amendment. All that other stuff.
Okay, I'm sorry. You're right. Okay. I just thought at first you asked, did the Constitution address it? I don't think it does. But yes, you're saying it's being addressed in law. Okay.
Yeah, it's already been addressed. So what needed to be addressed with the 14th Amendment was, what are we going to do about the slaves, the ex-slaves?
Right.
That's all because
they had to overcome Dred Scott too.
The only people who this was supposed to address were the people who were ex-slaves because they weren't considered citizens, but they were born in the United States. Period. Anybody else didn't matter. Sorry, you don't fall into this whole 14th Amendment discussion. It doesn't. And that's why I keep saying it only applied on one day. Not ongoing.
I've not heard anyone give that view. Like I've listened to a lot of people talk. It's an interesting view. Hell, you may be exactly right, but given the fact that they're addressing the end of slavery, let me just back up and say this. This is the key thing, and we've discussed this off the air. And subject to the jurisdiction thereof is the key issue.
Well, hold on.
That's where everybody's arguing about.
Got to answer to that. Because I had to do some research about it. What that means is, because there are people who are not subject to the jurisdiction of the United States that are here. They're diplomats. That is where who else would it be? Because that's where diplomatic immunity comes from. They're not subject to the laws of the United States. Jurisdiction. They are not subject to the jurisdiction of the United States.
Okay, well, this actually came up in one of the arguments I saw between two parties, and a woman that was arguing for everyone born here as a citizen was a former prosecutor. And her argument was that you, by the nature of like breaking a law in the U.S., meant you're subject to the jurisdiction thereof. And the guy countered that, who believed as you do. Well, he sides with you that he doesn't think this is a get into the country free card just to be born here. He was saying, well, no, you could be subject to the jurisdiction of another country because you are still subject of another country. You are a citizen of another country, but it doesn't mean if you go down the street and start shooting people that the United States in that particular jurisdiction doesn't have the jurisdiction to prosecute you.
Unfortunately, she's wrong. Unfortunately, for the fact that this is common knowledge here, that they cannot.
Who's she on this? Because she was the one arguing that she had the jurisdiction to prosecute someone from the outside that otherwise was not a citizen.
Well, but she's talking about two different things. Remember, diplomats have special privileges. Very special privileges. And as a matter of fact, John Bingham, the guy who pretty much wrote the 14th Amendment, specifically addressed this. And he said that if they allowed people who were diplomats to fall into this category, they would be considered super citizens because they could come and get dual citizenship and then claim that their diplomatic immunity and go and do whatever they want, essentially. That's what he said.
Okay, this is something that, and all the people I talked about, that is the key number one A1 body of people that always gets brought up of, not subject to the jurisdiction thereof, are like people here on diplomatic relations. Okay.
I don't even know why this is, like I said earlier, man. How about we just go back to the person who wrote it and he can explain? If you just read what he says about this, it's in pretty clear English as to what he meant.
Yeah, but that gets back into what I said about the art of statutory interpretation. There are layers. It's kind of like if you can't win at the first layer, you're going another layer, because the people that go with the plain text would always say, like, hey, what does the text say? What does the text say? Period. And then the person that wants to argue, yeah, they wrote that, but they meant something else.
No,
and then,
but again, man, this is a very special case where we pretty much know who wrote it. Just read what the guy wrote.
And they pretty much know who wrote the Second Amendment. And that's one of those ones, too, that everybody has an argument over. You know, like, well, what do they really mean by well-regulated? It's like I said earlier, Madison knows what he meant. And if you read Madison and other writings, you can kind of figure out he meant no standing armies. That's why I've made that argument. Okay, that's what he meant, but it's not clear in 27 words or whatever in the Second Amendment.
Understood, but the 14th Amendment is clear. It's not vague. It's not really vague like the
not
Second
vague
Amendment.
As to what?
As in what the language meant and so on and so forth. Just read what John Bingham wrote about it and his arguments about this. It's pretty clear, man. I don't even know why this is up for debate. I really don't. Mm-hmm. Just read what the guy wrote. And he's saying, no, this didn't apply to people who were here illegally. Of course it doesn't. It doesn't apply to diplomats and so on and so forth. He wrote all of this because all these questions were debated prior to the 14th Amendment. He wrote about this.
Wait a minute. All of what was addressed prior to the 14th Amendment?
These questions that we're having, going back and forth, that all these people right now are having, he addressed all this stuff himself. And
he addressed that 150 years from now, President Trump was going to issue an executive order.
No, what he addressed
and he was going to say that somebody that came into the country illegally and had a child wasn't a citizen.
Yes, he addressed that if you were here illegally, you weren't a citizen. Period. He addressed it.
Right, you're not a. But see, nobody's saying that's not true. Yes, the person here. Okay, say two people are here and they're clearly illegally here. Man, woman. Woman delivers child. The whole argument in question is if that child is born in the United States.
Dude, he wrote about this. He literally said that's not the case. If you're here illegally, you're not and your kid is born.
I know you keep saying you're not a citizen, but you're saying the child born of those.
That's what he said. That's what he said. Yeah. That's why
you had that quote.
Dude, I was looking for it beforehand because I took a screenshot of it months and months ago when this first came up. He literally talked about this stuff, man. That's why I said, whoever's making this an issue, they're making this issue for their own benefit versus just going to the person who wrote the 14th Amendment and all of his writings before and after, where he said, no, that's not the case. If people here who are illegal and they have children, their kids are not citizens because they were here illegally. He literally said this. I don't even know, again, man, I don't even know why this is up for debate. I really don't, man. The guy said they're not citizens.
Well, one of the arguments I heard, like I listened to a young lady that had written, and I looked into her law review article she wrote on this, and she talked about the people that are arguing that Trump doesn't have this authority because, the executive branch doesn't have the authority to declare someone not a citizen born here, etc. She went into she goes, well, the problem with that is in the 9th century, she gave many examples of members of the executive branch. And one of the examples she talked about, I think it was in like the 1870s, a person was born here of parents who were legally here, but subjects of another country. So they're here legally, they're living here, he's born here. They pick off and take off. Mom and dad go back to wherever. And he actually goes back and is reared there. That's where he actually lives growing up. So he comes back into the U.S. He goes, fire me off a passport. And they denied him the passport. The executive branch, a member of, I don't know, who issues it? Is that Department of State issues passport? Right. So whatever they called it at the time, the State Department of State, this person who's operating in this capacity says, no, you're not a citizen. But I was born there. But you weren't born of parents. They were legally here, but they were not United States citizens. So your birth on United States soil didn't make you a citizen. But her point was, it was the executive branch making a denial of this claim just from making a determination as a member of the executive branch.
No, I was about to say the State Department's part of the executive branch. So, okay. All right.
No. I'm just saying, she's saying when you watch CNN tonight and somebody goes, Donald Trump's doing something no one's ever done in the bullshit. She's saying there is plenty of examples of denial of citizenship made by members of the executive branch throughout the 19th century.
Mm-hmm.
Like it wasn't anything new. So she's saying that, like it or not, and of course, I think that's, I'm going to call it the elephant in the room, but I think that's so much of the issue here. I think a lot of people, because it's Trump, are knee-jerking into, well, clearly he's wrong on this, or clearly he's out of line. And I don't think that just because you hate Trump, and a lot of people do, that makes him necessarily wrong. And I don't think he really cared. In issuing the executive order, it's like, hey, I've thrown it out there. It's going to go to the court. Maybe he thinks with the number of appointments he's had, he's got enough of a bench there that he'll get by with it. Because, these federal courts at lower levels that have said, nope, we don't agree it's right. This is what's forced the issue to potentially go to the Supreme Court. And any other thing that goes to the Supreme Court, we know you're going to get down to this squishiness of, is it as a conservative court as people say it is? Because I don't know. I don't know how the court's going to determine on that.
No, I don't either. That's a great question. I mean, we'll see.
Yeah, and another thing that I see a lot in the writing, the outcome of this case could significantly impact the long-standing principle of birthright citizenship. So, it's what is the old saw that he who defines certain aspects of an argument wins the argument. If you get to define the terms. So one thing you certainly see commonly now is, well, we all understand that there's been this principle of birthright citizenship forever.
I have to correct myself, by the way. It was Senator Jacob Howard of Michigan.
Not Bingham?
Not Bingham. He co-wrote it with Bingham. And this is what he said. He said, at any rate, I did add a bracketed word for the quote for clarity. This is called a lie. Judge for yourself. That's something else. Don't worry about that. Here's an original quote from Senator Jacob Howard referring to the citizenship clause of the 14th Amendment. He says, quote, this will not, of course, include persons born in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers accredited to the government of the United States, but would include every other class of persons. Now, I don't know how any more clear it could be.
Well, in that thing I'm saying about maybe sort of a so slow pulsed and clear analysis of all of this is difficult in certain areas because of people's hatred for Trump. I do think that is a big part of this. You also have to think that there are probably many people who are taking certain positions as it relates to this because they want to make sure that as many people born of people not legally here are considered citizens as possible. I mean, there's a political aspect to all of this, and that's why I think it's unclear. I hear what you're saying. I do, and I think it's a really good analysis about what tense, this whole 14th Amendment was geared towards. But you also have to take into account, they're writing that, I think this is an issue, right? They're writing that 1868. Well, the 1866 Civil Rights Act that defined citizenship had already been enacted. So that preceded it. So I guess what I'm saying is, if you're in the 14th Amendment and you're saying it again, why wouldn't you reference as already determined by the act? I mean, because the 14th Amendment's kind of putting to a constitutional amendment that which the 1866 Civil Rights Act should have already done. And it's because of issues, like I said, of, yeah, they've got a congressional act, but the states aren't getting in compliance. So let's clarify this. And I'll tell you another example of that. I think I'm right about this. The Volstead Act was actually a congressional act that became the 18th Amendment. If I'm not mistaken, it was like they passed a congressional act saying there'll be no more transportation consumption. I don't even know if it said consumption, but no more importation, no more making of booze, et cetera, et cetera. And I think somebody threw up their hand and go, I don't know that we can really do that as an act of Congress, tell the states they can't do this. Okay, then we'll get a constitutional amendment. So the constitutional amendment basically made the Volstead Act law.
Okay.
Or it created it. So I do think that the 1866 Civil Rights Act certainly had this power, but they still felt it necessary to make a constitutional amendment. Looking at the language, let me take a look real quick at, all right, the 1866 Civil Rights Act was the first federal law in the United States to define citizenship and ensure equal protection under the law for all citizens, particularly aimed at protecting the rights of African Americans after the Civil War. It granted rights such as the ability to own property, make contracts, etc., and was enacted despite the veto, as I said. So if, again, you have this Civil Rights Act of 1866, and it's addressing citizenship. And let's see, it was mainly intended to wake up to protect the civil rights of persons of African American descent born in or brought to the United States. So they address both.
And it's everything that you're reading is a tense issue, as in it's always past tense. It's never fresh. It's never addressing something in the future. It's always something in the past.
Okay. All right, but that's an interesting point, though. I'm reading from 1866. The 1866 Civil Rights Act was saying born in or brought to. I don't know. I think 1808 was the year. All right, follow what I'm saying.
I know where you're going.
Pretty sure. Do you not think at the end of the Civil War there could have possibly been any slaves still in the United States that were born in Africa and had been brought to the United States or brought from? Okay.
No,
I'm
agreeing with you.
All right. Well, then the 14th Amendment wouldn't cover them.
Because they were brought here illegally?
Well, what I'm saying is...
Hold on, but answer that question. The 14th Amendment wouldn't cover them because they were brought here illegally?
No, because they weren't born here.
Mm-mm.
I'm saying, what if you could find one slave at the end of the Civil War that was now freed by the 13th Amendment that was not born on U.S. soil? Under the language of the 14th Amendment, would that person be covered as a citizen?
No.
I don't think they would either, right? So, but it was addressed, according to what I'm reading right here, it was addressed in the Civil Rights Act of 1866.
Do you think it was addressed, or did they just not admit that they were still slave or people that were brought in bondage after the law, and it was in 1808 was passed that no more slaves were to be imported?
Well, I think Charles, if we're sitting around the table in 1866 and the war is over and we're trying to ensure that the newly freed people, as freed by the 13th Amendment, are going to get recognized as citizens in this Civil Rights Act, I would certainly think we'd want to. I think somebody would raise their hand and go, wait a minute. Before we just write that they were born on U.S. soil, don't you think we ought to address the ones that might have been imported even after the fact?
Yeah.
Yep. Let's just go ahead and say. So if they addressed it there, I'm just saying I don't think the 14th Amendment under that language necessarily would. Unless you're calling them naturalized by the enactment. I mean, if naturalization came from, some other aspect of that, maybe, I guess. Because it says born or naturalized.
Remember, though, the 14th Amendment was pretty much written to address the issue of the freed slaves. And I seriously doubt they're going to say...
And I think that's all it was. I think that was all it was addressed. But I think they used language that could go forward.
I don't. I really don't. And the reason I say what I say is because what are you going to do? There were people who were brought here illegally, and you're going to say, well, sorry, you were brought here illegally. You've been here for 20 years or so, or whatever, and you're not a citizen. Of course they wouldn't do that. That would be crazy.
Okay. I'm not saying that the language of the 14th Amendment would have been written in a way to exclude those people from citizenship. What I'm saying is it wouldn't have been inclusive enough. Because again, you could envision a person that needs recognition of their citizenship. They're in need of it. And again, a lot of this again is pushed by the Dred Scott decision, because in Dred Scott, Tawney said that basically Black folks, regardless of their status, whether they're considered free, slave, whatever, didn't have any rights that needed to be recognized by the American government. That was the Dred Scott decision.
Well, the problem with that, not the problem with the Dred Scott, obviously we know what the problems were. Say, for instance, you were a slave that was brought here illegally. How are you going to prove it? You can't. So I would say that they would probably just rope all of them in together, and this one constitutional amendment will cover everybody who was enslaved at the time. Whether you were brought here after 1808 or prior to it, it would be nearly impossible to try to defend yourself as to, no, I was a citizen. I mean, I was brought here before 1808, or what it would be. That would be an absolute nightmare. So yeah, I truly believe that it was written and to encompass everybody who was in bondage at the time and was just newly released or newly freed. But that's it. It didn't cover anybody who came here after that, or today or tomorrow or whatever, and they came here pregnant illegally and had their kid, and their kid is automatically a citizen. No. Sorry.
See, we're going round and round, and we're in agreement. I know we're totally in agreement. I'm saying that sometimes this is just product of people sitting down. It happens in any legislation. I'll give you a bad example. I'll give you a really bad example. Going to give you a bad example. And it got fixed. And I didn't know this until I was teaching criminal law at college. When I was a prosecutor, Commonwealth of Virginia passed a statute called the stalking statute. Okay. And what do you think? It was 18.2-60.3, I think, if I remember correctly. And I had these domestic violence cases, so sometimes I would get this. What in your mind is stalking?
Dude, it could be almost anything.
I know, but if you talk to most people, it's like, hey, dude that got jilted by a girl and he won't leave her alone, right?
Okay.
All right, so now they're trying to write that into a law. So here's what they wrote. They wrote that if on more than one occasion you contacted said person and you made that person feel that they were an imminent threat of bodily injury, death, sexual assault, whatever, that's what it took to meet that. That's the wording, right? And it was said, a bunch of legislators, and I actually was in a room one time, and one of the people that was involved in writing, I was like, it was poorly written. She took offense, but here's what I was addressing. Here's what happened every time. Ma'am, please state your name, blah, blah, blah. Okay. Do you know Jimmy? Yeah, I used to date Jimmy. And what happened on May 3rd? Jimmy followed me to the 7-Eleven, got out the car, said, baby, I still love you. Please come back. Then I went to Piggly Wiggly grocery store. Jimmy shows up again. Mm-hmm. So we've met on more than one occasion. Every defense attorney was like, okay, so when you saw Jimmy get out, you were absolutely sure he was going to kill you. Well, I didn't think he was going to kill me. There goes fear of bodily harm or death. You thought he was going to drop you right there and rape you, like sexual assault. Well, no, I didn't think that. So he would step down everything that was said. And every time it would tend to be the judge was like, well, I have to go with even the victims saying they weren't in fear because of the way it was worded. So I'm talking about it years later when I'm teaching a class, and a young lady that worked at a woman's battered shelter goes, Mr. Moore, that's not the language now. I look it up in son of a gun. They put it was per se if you showed up on more than one occasion that you meant bodily harm. So they just wrote the law differently to address the fact that a lot of these cases were dismissed because you couldn't get the victim to say. The victim's being annoyed, and it meets the standard definition that these legislators were going after. There's people that stalk people. They're jilted lovers, whatever. They tend to want to run around and follow the old girlfriend and give her a hard time. So they're trying to write a law for that. But then they wrote in language that had to be reached as far as a level of threat that nobody really thought was it. So it kept getting dismissed. So they went back and rewrote the law. So I say that example, I use that example because the legislature had, it's a bad example, I'm sure, but the legislature had an ill that they wanted to address. Men that follow women around and give them a hard time, whatever, after, and sometimes it was former husbands, whatever. But then the law didn't work because of the language, so they changed the language. So my only point in this is, if the 14th Amendment was being used to address only the people that had just recently been freed with the 13th Amendment, the end of the Civil War, that language ended up creating an issue. It has created an issue for an open interpretation that means that everyone born in the United States of whatever parents who aren't excluded because their family's diplomats or whatever one of these other and it's been a very narrow group of classifications of people that fall out of this. But I think there is a fair reading that anyone born in the United States is a citizen if they're born on U.S. soil. I think that's a fair reading of that. But then you're like, oh, yeah, but there's another layer. And I get it. You're right. I think historically, if you brought back, this is the key, if you brought back everyone who was involved in the 14th Amendment, writing it, voting on it, whatever, none of them would think that meant that the illegal aliens could give birth to a child in California somewhere and that child be a U.S. citizen.
How do you know that?
I'm pretty sure that's not what they were addressing.
But how do you know that?
I don't.
Well, actually, you do, because you can read what they meant.
Yeah, you're saying saying, and that's okay. That's what I'm saying. But you wouldn't get it from the language of the 14th Amendment. Is what I'm saying.
Understood.
That's it. But that's it. Like,
hold on. One of the things that you told me is that you can read a law, but you need to go back and read other portions along with the law to understand what that law meant, right?
It only gives persuasive argument if this kind of thing happens.
Okay, well, same thing with this.
That's what I'm saying. It's like, so if we're going to go before, you and I are going before the Supreme Court, and we're arguing either side of this, what am I going to do? I'm going to lean toward, Your Honor, may it please the court, I'm going to go in there and say, hey, it says born in the United States. Then you're going to have to, at some level, and I get it, but let me go ahead and give you some history on what the framers or drafters of the 14th Amendment actually said about what they were trying to address. And that gives us persuasive argument. But you might get a justice on the Supreme Court, especially because of the political composition. It goes, I don't really care what those gentlemen were addressing, even if it was the newly freed slaves. I want it to mean this. And if they say, I want it to mean this, it'll mean that. Then it comes down to how many votes. It's 9 of them. I think it could go 5-4 very easily. It could be a 5-4 vote. In which direction 5-4, I don't know. But that's all I'm saying. But you're right. You could probably bring out the writings. And again, I keep going back to the same arguments, but it's like I said, I have seen some stuff with Madison was very, very clear about what the Second Amendment's about. And I got friends that were very well-educated attorneys like, well, that meant that you could only have a musket, a muzzle-loading musket. I'm like, really? You see that in Keep and Bear Arms? Well, because that was the military rifle of the time. I'm like, it wasn't the only military rifle, but that meant. So they read into it that the Second Amendment ensures your right to have a 1791 type of firearm. That's it. I don't read that in that.
No, it says, well, Rick, that's another story.
I know, but I'm saying, though, there are people that believe that. But I also think the people on the Second Amendment are wrong to say that the Commonwealth of Virginia couldn't regulate firearms. There was no incorporation. Yeah, that's all I'm saying. So in these things, I think that by some kind of accidents of history, they're addressing something and use language that's too inclusive. I think that's what I'm saying.
I will just say this, and I don't bring up race too often. I really don't.
Mm-hmm.
I just find it very irritating as to how there's so many people who use to their own benefit laws or amendments that were solely written for the intent to correct a wrong. The 14th Amendment was there to correct a wrong or an issue of what do we do about freed slaves. But you have people who are jumping across the border having their kid and they're saying, oh, well, but it says it right there. Affirmative action is the same thing. There are people, affirmative action, quote unquote, was there to correct a wrong or to level a playing field. But other people who it wasn't even written for were using it to their own benefit. How many more times or how many more examples do we have to come up with? This is the thing that really irritates me about this 14th Amendment thing. We all know it was not written for border jumpers to have their kids and their kids be citizens and they get to stay here too. That's not what it's there for. But those people use it. And again, as a black person, it's very irritating and it's a slap in the face. I'm just saying. And I don't bring up race that often, but it is.
Okay, I found that to protect all persons in the United States and their civil rights and furnish the means of their vindication, be it enacted by the Senate and House of Representatives of Congress of the United States, that all persons, this is what it said in the 1866, all persons born in the United States and not subject to any other foreign power, excluding Indians not taxed, are hereby declared citizens of the United States. And that as such citizens of every race and color without regard to any previous condition of slavery or involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall have the same right in every state and territory to make and enforce contracts, sue, be a party to suit, give evidence, inherit, purchase, blah, blah, blah. So they just go down through all these rights that have been enjoyed, and as is enjoyed by white citizens, and shall be subject to like punishment, pains, and penalties, and to none other any law, statute, ordinance, regulation, or custom to the contrary notwithstanding. So that, even though in this further thing, when it was a synopsis of it, was saying that it addressed those that may have been slaves not born in the U.S., it doesn't say that. It still says, again, everybody born here. It does go into previous involuntary servitude.
Dude, but again, man, we all know what it was written, who it was written for. The question today is...
Yeah, in the 1866, civil rights was clearly written for that purpose.
But the thing that we're dealing with today, it wasn't written for them. But they're using it to their advantage. We all know what it's there for. That's the irritating thing about this, honestly. It's very irritating, man.
Yeah, I mean, given the historical context, yeah. And again, the history that I read in the last couple of days when we talked about doing a show on this is, again, at the end of the Civil War, you really had a lot of concern with how was the former slaves issue going to be addressed? And there was all kinds of different things being said about how to address it or how it would be addressed. And this, and I keep harping on this though, but this legislative act of Congress in 1866 was to address citizenship and contracts and all these different things that it addressed.
For who?
And apparently, from every history I read, wasn't really going very well as far as implementation. So they're like, okay,
but
let's go to the 14th Amendment and put it into an amendment process. And then they did the 1870 reenactment of the amendment.
Dude,
I mean, not of the amendment, but of the act.
I agree and all of that, but who was it for?
Charles.
No, Jack.
I'm agreeing with you. It's all about the freed slaves. Okay, I get it.
But what's going to
happen?
But
it doesn't mean that they used an artful language in the 14th Amendment that could be applied today.
But what's going to happen in front of the Supreme Court? What's going to happen is there's the group of people who's going to say, "Oh no, it's everybody." They're only concerned about the illegals that are coming today. That's going to be their argument. The people are going to say, "Well, no, it's only for the slaves." The ex-slaves at the time, the people who are saying no, it applies to everybody, are pretty much just, it's a slap in the face to the ex-slaves. Technically, it is. And the reason that I say that is the ex-slaves didn't come here by choice. But they're going to say all the people who came here by choice, it applies to them too. No, they're not even close to being the same. This isn't even the same sport. So no, these rules do not apply equally. No. Again, it's really irritating, man. It really is.
I guess, again, I don't know. I guess I do at times, clearly on some subjects, maybe maybe default to more of a lens out of I don't want to say emotional, but if you were to ask me, do I think we have a very well-functioning society that loads of people can enter the United States in violation of laws that have been passed? Okay, people can enter. And those that do enter, who have a child on said U.S. soil, you could take that 14th Amendment reading that was geared towards a post-Civil War America to try to make right. And again, that term like make right, it was like, no, okay, We've had this war. There's been a constitutional amendment to abolish slavery. Here we are. What can we put, I say we, but what can be put in place to assure some level of equality in application of the law?
Dude, that's why.
Okay,
That's
so
why I
that's
say
what the
it only-
14th Amendment's addressing.
That's why I say it only applies to one day. You're literally.
I'm not
making
sure
my
you're
point.
not right. The more you're saying it, Charles, I'm not saying I don't think you're right, but I'm saying I clearly see how somebody could look at the language and say, oh, that means anybody born here now. But again, to finish my point on that, I can't see a functioning government that would allow people to enter illegally, have a child, and then create some status of citizenship. I don't see it. I don't see how it could happen. But I do see, from without the intent of the framers of the 14th Amendment, having written a document or an amendment to the Constitution that could lead to an opening to make that very argument. That's all I'm saying. Now, do you think that there's not going to be some identifiable members of the court right now that you know are going to vote for the interpretation that everyone born here of illegal parents or illegal alien parents? Yeah. And where do you think they're getting their reasoning from? They're seeing what they want to see. That's what most people are going to do in this argument. They're going to start with, I want this result. Let me argue back. And I've let the cat out of the bag. I agree with you. I don't think the 14th Amendment should have been used for this purpose or was ever intended to be used for this purpose. But I'm agreeing that I would concede that I can understand the reading of it that way.
Yeah. I think the people who are going to argue and say that, yes, they're all citizens, their first question is going to be, well, if you take their citizenship, what's going to happen to them? Not my problem.
Well, I don't think it's a thing of taking one's citizenship, because one of the things that he said is those who are already here, it's not affecting them. Those that have already been the children born on United States soil prior to this executive order are not affected.
Okay.
It's only going forward. So that right there takes care of part of it.
Okay.
Now, I guess, I don't know. I don't see how you work back on that. Because I don't know that this, to my knowledge, the Supreme Court, because everybody brings up that one particular case from 1898, and I think they see in it what they want to. Make some comments while I'm pulling that up.
Well, my comment's going to be, what do you do with people? What do you do with people who were here against their will, and now they have been freed? You have pretty much two choices. Either you can send them back to where they came from, which they didn't do, or you let them stay. If you let them stay, what are you going to call them? Are they citizens or not?
Right.
That's the whole purpose of the 14th Amendment. The sole purpose of the 14th Amendment. That's it. No more, no less. And again, I'm going to argue this until the day I die. It has nothing to do with anything in the future. It was to address those people who were at that time here with zero citizenship status. Zero. Not people who came here from another country. Already a citizen of that country. Their parents being citizens of that country. Because the freed slaves, in most cases, their parents were here as slaves. And their parents were here as slaves.
Yeah. Right.
So you can't say that those people came, their parents, they were citizens of another country and they came here. No, sorry. No. It's not even close to the same.
All right, here's the one. We have to discuss it. United States versus Wong Kim Ark, 1898, which is 30 years after the 14th Amendment. So it's 30 years later. It was brought up by one of the commentators I listened to today. That means these members of the Supreme Court were very likely already alive, and maybe some of them were already practicing law at the time that the 14th Amendment was ratified. So they weren't like foreign in time to that. The landmark decision, United States Supreme Court, which held that a child born in the United States of parents of Chinese descent, who at the time of their birth or his birth, at the time of his birth, the parents were subjects of the Emperor of China, but have a permanent domicile and residence in the United States and are therefore carrying on business. They were merchants. They weren't laborers. This is what another part of this case that's important is During the time of the Chinese Exclusion Act, to my understanding, it was trying to exclude the immigration of laborers. So these parents were merchants. They weren't laborers in that sense. But anyway, they're not employed in any diplomatic or official capacity under the Emperor of China. This child, became automatically a U.S. citizen. Wong Kim Ark was the first Supreme Court case to decide on the status of children born in the United States to alien parents. This decision established an important precedent in its interpretation of the Citizenship Clause of the 14th Amendment to the United States Constitution. Now, I've heard people argue quite a bit. Wong Kim Ark, on both sides of this, was born in San Francisco and had been denied re-entry to the United States after a trip abroad under the Chinese Exclusion Act, a law banning virtually all Chinese immigration and prohibited Chinese immigrants from becoming naturalized U.S. citizens. He challenged the government's refusal to recognize his citizenship, and the Supreme Court ruled in his favor, holding that the Citizenship Clause should be interpreted in light of the common law. The case highlighted disagreements over the precise meaning of the one phrase in the Citizenship Clause, namely the provision that a person born in the United States who is subject to the jurisdiction thereof acquires automatic citizenship. And again, the subject to the jurisdiction thereof, that's going to be the whole argument. And I listen to a lot of egghead intellectual lawyers and judges. Nobody can really come up with a real good working definition. Okay, Charles, you got to look.
Yeah, there
I'm
is a
not
definition
saying
of it.
subject's a word out of their dictionary or two, the jurisdiction. They're not sure in the context of this. Everybody's arguing something different. They're arguing different as to what subject to the jurisdiction thereof means in the context of the 14th Amendment. So it's not clear because it's a battle over it. Supreme Court's majority concluded that this phrase referred to being required to obey U.S. law. On this basis, they interpreted the Citizenship Clause to grant citizenship to children born in the United States with only a limited set of exceptions based on English common law. The court held that being born to alien parents was not one of those exceptions. Now, again, these parents were not illegally here at the time of the child's birth. I mean, that's one point there. The court dissenters argued that being subject to the jurisdiction of the United States meant not being subject to any foreign power. That is, not being claimed as a citizen by another country. And they get into the question of inheriting citizenship from one's parents, an interpretation which, in the minority's view, would have excluded the children of foreigners happening to be born while they're passing through the country. So there it is. That's the whole thing. If you're going to play apples to apples, if you're going to go apples to apples, this Wong Kim Ark decision versus what's coming up today, he had parents who were not U.S. citizens, who were legally in the States conducting commerce. They're not diplomats. They're not representatives of the Emperor of China. They're here legally. He's born. He leaves, tries to come back and say he's a citizen. And part of what I heard one of the historians say is that it was the fact that he did hit one of the narrow exceptions to the Exclusion Act is part of the reason they granted it. But there was a minority that says, no, he doesn't get back in. He was never a citizen. But then you get into the argument was he a Chinese citizen? But what is different in his case, which is clearly different than everything else going on today, is the parents weren't people that crossed the border and entered illegally. They're not. They were here legally. They just weren't U.S. citizens. And he was born. So what about that? Would you accept they got that right?
No.
So two parents here legally conducting commerce who are subjects of the Emperor of China. They're Chinese, and their son is born on this soil, but they're not here illegally. They're not diplomats. They're not acting as representatives for the Chinese government.
They're passing through.
They're passing through.
So I remember, I'm going to answer your question. Do you remember a few months ago, Tom Holman was asked a question, and I found the way he answered the question, it was so funny. It said, but you're breaking up families by doing this. He's like, no, I'm keeping the families together. I'm sending them all home. That's what I would do. Because really, because we have a legal question here. Say, for instance, the kid is a citizen. What right does his parents have? None. So you have a choice, parent. Either your kid stays here and you go home, or you go home and your kid goes along with you. Which is it going to be? Because what has been happening is they just automatically say, well, the parents can stay here too. No, who's supposed to take care of your kid? That's your parents' job, not my job. So either you go home and your kid stays here, or you go home and your kid goes too. That's what needs to happen. And I think that would solve the problem.
You know, I'm looking at an analysis that someone wrote on a law review about what does this subject of jurisdiction thereof mean. And they say the phrase means that individuals born in the U.S. are under the authority of U.S. law. And then they say it excludes certain groups from citizenship, such as foreign diplomats, foreign armies. That's another one that I read quite a bit of. Like, hey, what if you got an invading army and the kid's born on the land? That doesn't make him a U.S. citizen. If that country's in here, they're clearly not citizens of the United States, and you're not here on a work visa. There is if there were an invading army.
I mean, kind of like John McCain.
So John McCain was born on a naval ship.
No,
was my understanding.
No,
he wasn't.
He's born in the Panama Canal Zone.
Okay, gotcha. They were on a ship. I guess they went ashore for him to be born.
So,
right.
Well, they wouldn't have been on the ship anyway because his mother was not in the Navy.
So he was stationed there. He
Right.
was. I thought they were at sea actually or whatever. But okay.
So
yeah, why would the mom be on the ship? You're right. Okay, whatever. But he's born in Panama.
Yeah, he's born in Panama. That doesn't automatically make him. I understand that those laws are different than ours. That's fine and dandy, but still, that made him eligible to be president.
Well, there were people that still argued against it.
No, it was foreign.
I understand that would have been the ruling, but I mean, that was the ruling, but there were still people that said it says on soil, and that's not on soil.
Well, that is at the time it was in soil. That was American
because
soil.
he was on a military base.
Yeah, exactly.
And it makes the military base okay.
Yeah.
All right.
Yeah.
Okay. Definition and context. It excludes certain groups, foreign diplomats, foreign armies, Native American tribes, historically considered a quasi-sovereign entity of itself.
Right.
Historical interpretations. The original intent of the clause, this is what the argument is. The original intent of the clause was to ensure that all persons born in the United States are citizens with limited exceptions. The Supreme Court case in Wong Kim Ark, 1898, affirmed that children born in the U.S. to non-citizen parents are citizens unless they fall in the specified exceptions before listed.
That's fine.
Implications for citizenship. Generally, non-citizens present in the U.S., are considered subject to the jurisdiction and must adhere to U.S. laws. The clause was designed to reverse previous legal interpretations that denied citizenship to certain groups, particularly African Americans. The framework has shaped the ongoing discussion. So I think based on this, that United States versus Wong Kim Ark could have been properly decided. But what they don't give is one of the exceptions is someone here illegally as a parent.
That's the key. And that is the issue that we're having. If it wasn't for the illegals, I don't even think this would be a question. I don't think this would be an issue at all. But it's the illegals that come here and do this. That's what everybody's up in arms about. And I think,
well, no doubt.
It should be a no-brainer. If you're here illegally, what the hell are you talking about where my kid's a citizen? You weren't supposed to be here.
Well, and that was one of the criticisms I saw on everybody keeps throwing out this one particular 1898 case is that it's not saying what the people that support crossing the border illegally and having children is saying. It's not saying that.
It's not the same situation at all.
It's not the same situation.
No.
And I agree with that. But that is like a lot of the people I heard arguing for cross the border, have the child, everybody's a citizen. They kept saying, well, what about Wong Kim Ark? They decided it right there. Yeah, but that's not what they're deciding.
No.
Yeah, I would agree with that.
Yeah.
So, all right, so we've gone a little over an hour, so it's about time to wrap all this up. Yeah, I still think the more I read this and kind of we discuss it, I think 5-4 in favor of Trump's executive order is possible. 6-3 maybe, but I think if there's a 5-4 vote, I don't think it's going to go against that he had the authority to do this.
Man.
Question's going to be, will Congress ever get into passing
a
law? I mean, right now it's an executive order. Next president, you get another Joe Biden, Obama, whoever. I mean, any president, well, I would say anybody from the Democrat side, the first thing they're going to do is kill the order.
So the executive order to reverse an executive.
I think all the Supreme Court can do. All right, let me think about this.
Yeah.
All the Supreme Court can do is uphold the executive order. But I think the executive order is still an executive order. All they can do is say, yes, Trump, you're constitutionally within the bounds of what you're doing with the executive order. It doesn't make it law. I mean, it doesn't make it a lasting law outside of its administration, unless I'm missing something, right? So, yeah, it lasts until.
Well, hold on. Oh, but could this not result in the Supreme Court clarifying what the 14th Amendment is?
Yeah, I mean, I think it brings up that brings up another one of those great points because, I mean, if they rule like, hey, we're ruling that the 14th Amendment did not intend to include the person here illegally having child. That's not what the 14th. Okay, so they make that ruling. And then therefore, I think what they have before him is the executive order as established and written. Is it constitutional? But it doesn't make it a law. I mean, unless I'm missing something, unless Congress passes a law.
Well, there is no law. It's the 14th Amendment. It's already a law.
Right.
It's just clarifying that, what we have been doing when it comes to this amendment was unconstitutional.
I guess you're right. I guess, I'm thinking about if somebody pulls the order, though, are you back to, I guess you're right. If the Supreme Court, if they address it, I think all this before them is whether or not let me finish on this. If the executive order is constitutional, but if what you're saying is by saying, yes, it's constitutional, now they're ruling that the next president comes in and says, screw the executive order, it's expired. I have a new executive order said, come in and have as many babies as you want, then that could go to the Supreme Court, I guess, and then that could be overturned by this last decision. But there's still no, this is an interpretation of the 14th Amendment. I agree. It's an interpretation of the 14th Amendment. And the question is, what legal authority does the United States have to exercise not granting citizenship going forward?
Well, it all depends.
You're right. I mean, I guess if they rule on that and they say, yes, it is an order, though, and you're just saying it's a recognition of what the 14th Amendment actually says. Yeah, I think you're right. Until it gets overturned. Yeah. I don't know how you would execute a new executive order to overcome it. That's true.
Right. That's my point.
Yeah.
Anything contrary to this would be already ruled unconstitutional.
True. Yeah. So I guess that's enough to speak on that.
It all depends on how this executive order was written. And I'm sure they wrote it for it to go to the Supreme Court to answer the question. I'm sure.
I think there's no question that when it was being drafted, that there was every expectation that, this is going to end up going to the United States Supreme Court. And let's kind of get a ruling on it. I've looked at a little bit. I will cover that a little bit here. On Thursday, Acting Solicitor General Sarah Harris asked the Supreme Court to allow President Trump's executive order to go into effect outside of the 3 districts where preliminary injunctions were placed into effect, and let the Justice Department start planning on how to implement the executive order, blah, 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 blah. The executive order at issue protecting the meaning and value of American citizenship was signed on 20 January. The day it was inaugurated, 2025. Under the order, United States citizenship would not automatically extend to persons born in the United States. When that person's mother was unlawfully present in the United States and the father was not a United States citizen or lawful permanent resident at the time of said person's birth. Or 2, when that person's mother's presence in the United States at the time of said person's birth was lawful but temporary, such as but not limited to visiting the United States under the auspices of the visa waiver program or visiting on a student work. Okay, so they're covering some other things. And the father was not a United States citizen or lawful permanent resident. As legal justification, the order asserts that the 14th Amendment has never been interpreted to extend citizenship universally to everyone born in the United States. It has never been interpreted as. The 14th Amendment has always excluded from birthright citizenship persons who were born in the United States but not subject to the jurisdiction thereof. It then states, among the categories of individuals born in the United States and not subject to the jurisdiction thereof, the privilege of the United States citizenship does not automatically extend to the categories of persons excluded from citizenship by the order. The injunctions from the 3 district courts in Washington, Maryland, and Massachusetts bar the executive order from going into effect. Okay, it bars it. Okay, I guess you're right. I'm just trying to think about mechanically how this is going to work, because what's at issue before the Supreme Court is there's an executive order and these people have filed injunctions against the executive order.
Yes.
So you're right. They're going to make a statement as to the constitutionality of the executive order. And by doing so, when they say Trump's right on this, or, yeah, these people aren't citizens, that's not what the 14th Amendment intended, then they've spoken on that. That's true. But his executive order will still expire, and it's not law. I mean, it's not a congressional act, and it's not a constitutional amendment. So I guess at that next point, regardless of whoever the next president is, writes or doesn't write, anybody that attempts to do that again won't be recognized as a citizen. I see the face. What are you doing?
No, the expiration part. I don't think that.
Well, the executive order expires with his term.
Oh, no, I don't think in this case. So you can have an executive order that says to follow the Constitution, and it expires, and we just go back to not following the Constitution.
No, I'm not saying that, Charles.
No,
I'm not saying that.
No,
I'm saying that any challenge to get citizenship after this, based upon illegal alien parents, is going to fail.
Hold on. What I'm saying,
but it has nothing to do with the order anymore.
Listen to what I'm saying, man. Trump's executive order is saying essentially to follow what the 14th Amendment says. Okay.
No, he's saying interpret the 14th Amendment as I see it.
Hold on, let me finish.
And maybe they will.
Let me finish, Ren. His executive order says to follow the 14th Amendment. Okay. If it expires, that essentially is saying to automatically go back to not following what the 14th Amendment says. That's why when the Supreme Court goes through this and says, executive order be damned, follow the 14th Amendment, because this is what it's supposed to mean. Executive order doesn't matter. It doesn't matter if it expires today or tomorrow. It doesn't matter. You have to follow the 14th Amendment.
Okay. Presidential executive orders remain in force until they are canceled, revoked, adjudicated unlawful, or expire on their terms. The new president may review, yes. They do expire.
Jack, listen to what I'm saying, man. This is not about his executive order expiring, man.
I know it's not.
Listen to.
That's what I just said. I said if they rule in favor of the 14th Amendment in the way that Trump wants, then it becomes.
Then why you keep bringing up
a violation of it?
Then why you keep bringing up the executive order expiring? That has nothing to do with it.
Because when the executive order expires, what if somebody says I was?
Jack, listen to what I'm saying, man. This specific executive order, it doesn't matter if it expires or not, because if it goes to the Supreme Court, and the Supreme Court says that you have to follow the 14th Amendment, that executive order was only.
They're not going to say. They're not going to say you have to follow the 14th Amendment. They're going to say we interpret the 14th Amendment to say what Trump says.
So it doesn't matter if the order expires.
It won't matter. You're right, but the executive order will expire. Or he may even cancel it. It won't matter.
So what? If it doesn't matter, man. The whole purpose of the executive orders.
That the Congress shouldn't address it with a law.
Dude, they already addressed it with the law back in 1868. That's the whole reason that the executive order doesn't even matter.
That was a constitutional amendment. The act of Congress was on both sides of it. But I still,
I don't know why you don't understand this point, man. The executive order
it's not that I don't understand the point. I'm saying that the next person who tries to claim citizenship because they were born in the U.S. will lose.
The thing is, listen to what I'm saying, man. The executive order was just a vehicle to get it to the Supreme Court.
I don't disagree.
It doesn't matter if it doesn't matter when it expires. It doesn't matter, man. It doesn't matter at all, because what is somebody going to do? Come up with an executive order? And the Supreme Court has already ruled on it 2 years ago. That executive order was automatically unconstitutional.
I don't know what would preclude a president from having an executive order to try to goose it in another direction.
Good luck with that when it comes to this.
I don't know, man. There's been a lot of executive orders that I think are way out of bounds, but they'll still do it.
This one, there's so much evidence to the contrary of all these people who say it applies to everybody. Bruh, good luck with that one.
We're not I was only bringing up the point that I don't know. A lot of times Well, with this, I think what's going to happen is you have to think the practicality of what if somebody challenges all this and says, hey, I was born here, regardless of this decision? Because I don't know how far the Supreme Court's going to go either. I don't know. I mean, they may go to the point to say exactly what Trump is saying the right way. The only thing I'm saying is there's an executive order. It's going to be ruled upon. Maybe they use the kind of language that excludes anybody else from claiming who was born with a parent that's an illegal alien, both parents, whatever. They may address it to the point that's going to preclude anybody else from making that claim. I accept that. But I'm saying right now the basis is under an executive order. They're going to rule on the order, and the order will at some point expire. But if they're inclusive enough in their, all I'm saying is if they're inclusive enough in decision, I think it would be pissing up a rope to say that, yes, I was born here, regardless of the status of my parents, I'm a citizen. We've already addressed that. We've given a hard, fast rule.
Yeah, were I arguing this in front of the Supreme Court, I would first bring up that Naturalization Act, the first one from 1790. I would start there and then say, well, everybody else, well, there was only 3 groups of people who it didn't address. They would be the Indians, the diplomats, and the freed slaves. And the 14th Amendment addressed all that. Everybody else, you need to be you need to be here legally, or a naturalized citizen. And again, it's already in the act. It's already there.
Yeah, but I also saw in that language that Trump had in the executive order, and I don't know how they'll address this. If I'm not mistaken, I just read that you could be here like on a student visa, have a child, doesn't mean it's a citizen. They're not here illegally, right?
Right, because you're passing through.
Right, it's the passing through thing, right? So I don't know how much
it was that was addressed. They were called foreigners.
Right. Okay.
It was, again,
but they're
it's
here
addressed.
Legally.
Yeah, they're here legally.
They're here legally, though.
But they're foreigners.
So, all right, and I think that's an important part of the argument too. Those that would be arguing the other, they would be saying the only lane that would create the citizen is to be illegal.
No, you can come here and get naturalized, and then you're legal, and then have a kid.
Then you're a citizen. I'm not saying that. Listen to what I'm saying. Listen
I understand, but this is about
what
the
I'm saying
kids.
is the person that's here as a student visa and has a child is not recognized.
Dude, this is about the
same
children.
Person would argue that the person here illegally is.
No, but remember, this whole issue is about the children.
That's what I just said.
No, that's not what you said. You talked about the person who's naturalized. This isn't about naturalization.
I didn't say anything about anybody being naturalized.
A student who's on a student visa.
Yeah.
No, they're foreigners.
They're not a naturalized citizen.
Understood, but you can be, if you're here on a student visa and you have a kid, sorry, your kid's not a citizen.
Charles, and the only point I was just making is there's an irony in the fact that you could be legally here from another country as a student on a visa, have a child, and no one would say, oh yeah, that child just became a U.S. citizen because they were born on U.S. soil. Yet, if you cross the border illegally and had the child, there's a whole group of people that say that is a citizen.
And that is my fault that I misheard you. Yes, I misheard you.
Okay, right.
Yes.
That's what I thought you heard what I was saying. I was like, yeah, I just think that's kind of a weird irony.
Yeah.
They're like, no, we recognize the kid, the young lady here on the student visa doesn't have a child that becomes a citizen, but the person who crossed the border illegally does.
Yeah, it makes no sense.
And that's what they would have to say.
Yeah, that makes zero sense.
Right.
I agree with you.
But I do think, maybe I'm wrong, I'm spitballing, all this is off the top of my head. I do think, though, that passing laws that are more in line with the Supreme Court's decision might not be a bad idea.
Yeah, I could go with that.
Yeah, because that usually is kind of, if you really want something done, presidents write executive orders all the time, hoping that they'll get congressional power or get enough congressional will to codify it in law. Because if you don't, it goes away. But I agree with you. I misspoke on that. Definitely, I agree with you that but again, it's if the Supreme Court addresses it specifically enough.
I agree with you on that.
Because I think you could still have these things pop up again.
Yeah, we'll see.
And I don't know. And I still think the Supreme Court could address this without overturning the 1898 case. I don't think they have to address that at all.
No,
but these people are saying that established this birthright citizenship.
No. I think
I
think I would be able to shoot holes in that one. I would.
But it's okay. Well, the dissent thought so too. That is the last thing I'll say on this is it's one of the things I used to say, teaching criminal law cases or teaching criminal law, at the levels I taught it. But what does a 5-4 decision of the Supreme Court really heavily imply?
That it was ideologically based.
That, and it's a coin flip, right? I mean, it's kind of a coin. So when everybody says like, well, the law is clear. Well, if it's a 5-4 decision, it could be totally politically where someone falls on that. But you don't get a lot of 9-0s. You get some 9-0s, you get some 8-1s, but a lot of time they're 5-4, and 5-4 simply means political will.
Right.
They're interpreting what they want to do. And I think it's clear, and you've really pushed me in the direction of thinking with everything you've said. You've pushed me more and more in the direction that I think the right ruling would be to rule that the 14th Amendment did not, based upon the historical stuff and all the other arguments you've made. I agree with you that I don't think the 14th Amendment was intended to create the cross the border illegal and have child and create citizen. I agree with you. However, 3 are going to vote for that.
Yes, of course.
And then the question is, can you get 4 and 5? And it clearly wouldn't make it right. I don't think it would make it a right interpretation or anything else. But I do see the language of born in being enough to, it all comes down to, again, the jurisdiction thereof. Anything you want to say in closing?
No, I'm good.
Well, you were great tonight, that's for sure. And we definitely got spirited, I guess.
Yes.
But it's a tough subject.
Yeah, we'll see. Was the arguments on the 1st, I think. First,
yeah,
or something like that.
Did I say April 1st or April 4th? I think it said April 1st. I think you're right. It's April 1st, which is a
April Fool's
Friday? No, wait a minute. 6th is Monday. 5, 4, 3, like a Wednesday, right? Yeah, Wednesday, April 1st. I think that is the day. All right. Love you, brother.
Love you too, man.
Appreciate it. And we'll do this again soon. Take care. Oh, yeah. So people that listen, like, subscribe. What is it? Like, subscribe, comment, share. Yeah, have fun. All right. Thank you very much. This has been More to Consider.
Thanks for tuning in. If you like the show, subscribe and hit your notification button to get an update when we post another episode. See you soon.